And welcome to this live, fully active webinar brought to you by the Monroe County Bar Center for Education. Today is April 22nd, and this is Let's Get Ethical, a roundup of common ethical pitfalls hosted by the Academy of Law of the Monroe County Bar Association and by the UB Law Alumni Association. My name is Laura Ann Godley, and I'm an appellate court attorney at the Appellate Division 4th Department and am CLE Committee Co-Chair for the UB Law Alumni Association. Keep an eye out for more digital programs from the Alumni Association, such as our next Free for Members program on May 7th. To comply with the accreditation regulations, please fill out your affirmation form and evaluation sheet at the end of the program and email it back to Danielle Matias, and in exchange, you will receive your certificate of attendance after the program electronically. Please note that all attorneys must attend programs in their entirety to receive credit, and according to the New York State CLE Board, CLE providers are prohibited from issuing partial credit. We all know this, but it has to be said. And please note everyone's line has been muted for the presentation portion of the session, and if you have any questions, please pop it into the chat in the Q&A feature. And you can also send questions to fellow audience members or to the host if you have technical difficulties. After our speakers complete their presentations, we will be unpacking 3 hypothetical situations and entertaining questions. Now, I will hand over our presentation to my esteemed co-chair, Patrick Levy, who will introduce himself and our speakers. Thank you for coming.
Hi, everyone. Patrick Levy. I am an appellate court attorney at the 4th Department with Laura. I'm co-chair on the UB Law Alumni Association, the Rochester chapter, and so thank you for everyone for coming. I will introduce our first speaker today, Gregory Huether. He is the Chief Counsel for the Appellate Division 4th Department. He oversees the staff of 3 offices in the 5th, 7th, and 8th Judicial Districts. He was appointed to this position in April 2007. Previously, Greg served for 22.5 years as a special ADA for Monroe County, and he also worked in private practice for 3 years. He's a graduate of the Western New England College of Law School. Greg, I'll turn it over to you. I'll mute myself, and you can unmute and kick us off.
Thank you very much, Patrick, and welcome everybody in the audience and to my fellow colleagues on the panel. I want to first commend all of you for having the enthusiasm and energy and desire to do a program under our current circumstances. These times are difficult for all of us, and I hope that you're all doing well and staying well. And there's no telling when we'll return to normalcy or what normalcy might look like, but in the meantime, I'm appreciative of the opportunity to contribute to your program, and I'm grateful for so many people participating by virtual reality. If I can, I just want to start by pointing out that materials have been provided, and I've posted a several-page outline citing the authority for our office and its rules, the structure of our office to some degree, and where our authority comes from. There's also a lot of citations as to where you can look for ethical guidance in terms of resources, in addition to the Appellate Division website at the 4th Department. But I would like to also point out there is a chart which is at the last page of my materials, and that points out kind of the process of how a complaint is handled. So my overview is to tell you that the written materials are, I think, helpful, and they will give you good guidance if you need to seek it. And I want you to also understand that I would like to speak to you today, not only with the idea of giving you an overview of our process, but also to ask you to think about this in a couple of ways. And one is the obvious one: what if I ever have a complaint made against me? But in another way, I would like you to just kind of sit back and absorb our principles and our philosophy a little bit, because what if you knew someone who had an issue with our office and was the subject of a complaint? We encourage other fellow attorneys to step in and help attorneys who have become the subject of complaints in order to guide them. And we have very much found that when an attorney is in trouble, they're probably their own worst defense counsel. They don't see the problem, they don't see all the issues and really understand the nuances, if you will, that perhaps an objective set of eyes can provide. So we encourage people to help one another. And in terms of the opportunities to help people, I want to provide an overview and an explanation. As Patrick just said, I was a former prosecutor, and I've been very clear since I was appointed 13 years ago. We are not here to prosecute people. We are an arm of the court. The court themselves cannot conduct investigations or conduct the trials against someone who has more serious allegations against it. So there's a process that I'd like to give you. And rather than worrying about taking notes and worrying about every single thing I might say in the next 20 minutes or so, I'd like you to kind of get the concept and the overview and the philosophy that I want to share with you. Because as I said, we are not here to take down attorneys. We are here to address issues. And I think our purpose is threefold. And number one, it's to protect the public from unscrupulous behavior and misconduct by attorneys. That's certainly true. The second aspect is to protect our profession, both from those who might engage in misconduct, but also from unfounded accusations against attorneys, because obviously your reputation can be harmed and damaged. And the third is to educate. And we try to educate both the public and the complainants who come to our office, but also to educate attorneys, because sometimes misconduct is not by desire and by design and saying, I think I'll break this rule, but by sometimes not knowing what the right rules are and what should apply. So we're here to guide attorneys and try and get them to take corrective action so that they don't repeat it. And obviously when we see people who constantly repeat the same misconduct, they're not listening, we're not getting their attention. But many times they come to us and they say, I just didn't know that. And so we're here to educate attorneys as well. As Patrick mentioned, and as the outline mentions, we are a structure of offices in the 4th Department that are in 3 different judicial districts. So geographically, I have offices in the 5th District, which oversees Syracuse and the surrounding and northern counties of that. And then I have the 7th District office, which covers the 7 and 8 counties in the district down to the southern tier. And then I have the 8th District office in Buffalo, which has all the other counties, all the way out to the western perimeters of our state. So there's 22 counties involved in the 4th Department, and we oversee that by the 3 district offices. Each of my offices has staff attorneys who are assigned to that, as well as secretarial support, and they intake the cases. And then we also have a staff investigator or an analyst, and they respond and they build the file, they dig out more information, obtain records and documents for us, and so forth. So I oversee the operation, and my home base is in the Rochester office because that's where I live. But I travel back and forth to Buffalo and Syracuse, certainly for all the meetings and all the committee meetings that are attended that we conduct in those offices, but also many times for just a day with my staff. In terms of complaints, between those 3 offices, we take in typically anywhere from 17 or 18 or 1900 to up to 24, 25, sometimes 2600 complaints a year. And those are divided about 30% in Syracuse, 30% in Rochester, and perhaps 40% in Buffalo. And that doesn't mean the Buffalo attorneys are worse behaving. It's strictly divided by geographic and by population of those districts. So we get a number of complaints, and that winds up being several hundred complaints in each office per year. Obviously, that's a lot, and we do review each and every one of those complaints. But I will also tell you right up front that many of those complaints, if not nearly half of them, are sometimes dismissed, opened, and then closed. The reason for that is simply because many times people are unhappy. They lack certain information. They think that the attorney is not returning a phone call or didn't do something properly. They simply don't understand. And managing client expectations is a huge way of avoiding complaints, because if you lay it out and the client understands it, very frequently, even if they don't agree, they don't file a complaint. What we require in order to have a complaint is that we must have an original document. It can be a letter, it can be a form, which is on our website now, but it must be a signed and original complaint. We do not take complaints by email or fax. We don't take them by scans. We don't take them on word on the street. We don't take them by someone else telling us what they heard from someone else. We require an original complaint. That's to ensure authenticity and that it's a genuine, true complaint. And we don't take them anonymously. It must be signed. It cannot be unsigned complaint and an anonymous donor. We won't respond to that, and we won't open that up, and we won't ask you to respond to that. The reason for that is to ensure that it is an authentic complaint. And as I said, we're here to protect the profession against unfounded complaints. We also want to emphasize that everything that we do is confidential. When we receive a complaint, there's no disclosure of that fact, other than perhaps to the attorney who was complained of. But our process that I'll describe in the next several minutes is confidential, from originally receiving a complaint all the way up to and including when and if the court decides to issue a public order of discipline. Until that happens, we assure people of complete confidentiality. So when someone writes to us, we tell them, everything that you are doing here will remain confidential, and we encourage them to do the same. When a complaint comes in, it gets set up in a file, and we run the history, if there is any, of the attorney that is being complained of. That it comes from our database, and once a file is set up, it goes to our office analyst or investigator. That person reviews the file to see if there are documents that are also missing. Do we need bank records? Do we need other things that are referred to but not included in the complaint? Once we feel that we have the complaint sufficiently built, then that person will have a staff intake meeting with my office's attorneys. So in Buffalo, there's a process, in Syracuse, there's a process, and in Rochester, there's a process. And all of the attorneys collaborate and do a roundtable discussion and review of these cases. Our threshold determination is simply this: would the allegations, if true, constitute professional misconduct as that term is defined? And our rules are in 22 NYCRR at 1200 and 1040. And you can look at those and see the definitions and so forth. But the threshold issue is, would this complaint, if it was true, constitute professional misconduct? Is there possibly one or more rules being violated here? If there is not, then we will open that matter, as I said, but then we will close it at that point. We send a letter back to the attorney, and we send a letter back to the complainant, and we try and explain that even though we understand that you're unhappy about something, this complaint does not constitute a breach of ethics, and therefore it is being closed. I mentioned that the attorney gets a copy of that letter because that's important. Many times you might receive a letter from my office, and I know that that is a scary letter to receive, and we've heard anecdotal stories from attorneys that they put it on the side of their desk for 2 or 3 weeks or 2 or 3 months. They didn't even want to open it, they were scared. But sometimes it's actually good news. There was a complaint made, and it's unfounded, and we're not taking any action. So please don't be paralyzed by the receipt of an envelope from my office. Secondly, if there is an allegation that might be a complaint that has merit, then we're going to open it and we're going to send that to you for a response. We will ask you to provide a written response within 10 days or 14 days, and we will give you a deadline. And if you need more time, simply call and let us know. We're happy to adjourn it if you're on trial and you're out of town or unable to respond in the time we've set because you didn't know that this was coming. But if the matter is open, you'll get the original complaint, and you will see that it is perhaps by a client. Sometimes it is perhaps from a judge. Sometimes it is by someone who witnessed something. But if we think there is something worthy of answering, then we'll ask you for a response. In that response, we ask you, please be candid, be truthful, and if you are concerned and it's a serious allegation, seek counsel from someone else. Seek counsel to review it with them and to help you in your response. All attorneys are obligated to respond to the grievance process and to provide a written response when asked. And therefore, it is important that you cooperate and that you independently review the complaint and try and give us further information or more to the story. Very often, we find that complainants are unhappy and they are saying things which are disturbing, but they might be totally something that you can refute. They may say you never communicated with them about your case. And you can produce several letters showing that you did, and documentation of phone calls and emails and other ways of showing us. The process that we follow is to take your response and then return that to the complainant and say, this is the response we've obtained. If you have any further comments, please provide them to us within 14 days. Many times we find that by providing the rest of the story, as Paul Harvey might say, we find that the complainants go away. They drop their interest. They are no longer interested in dealing with us. They realize that perhaps their attempt to complain about you is really an attempt to not pay the rest of the bill, or to just be unhappy because they didn't get something in the divorce they thought they should have, or that you just did a lousy job. Those are subjective feelings, but they're not grounds for you to be concerned, and they're not unethical behaviors. And a lot of times complaints get resolved by you providing a candid and full response. So that's to your benefit to do that. Sometimes we hear that the attorney has not told us the entire truth and the answer. And when we send it back to the complainant, they say, well, what he's telling you is untrue. Here's some other letters that he sent to me which show you that couldn't be the case. We get those comments back, and now we as a staff revisit the case and look at it. In our process, we have the authority to compel an attorney to come in and actually be interviewed. And we have two different levels of that. One is called the formal interview, which is an interview with my staff and my analyst. And that is a question and answer session. And again, you're welcome to have counsel with you and to bring along counsel in order to review and participate in that process. We welcome it. But if you are asked to come in for an interview, then you should. And if you can't make it on that date, we'll work with you to find a date that does work. On a more serious note, we might have an examination under oath, where we feel it's necessary to have a court reporter and actually take down what we're asking you and what you're saying under oath, and a transcript will be created. And again, if you want counsel, you should do so by all means. But you are obligated to respond to that. And if an attorney doesn't cooperate and doesn't respond as scheduled, we have the authority to then subpoena you by seeking the authority from the court. If you are subpoenaed and you fail to show, my offices have then taken the stance that you are non-cooperative. And that is a separate act of misconduct, just as lying to us in your responses would be. So you want to cooperate, you want to be candid, you want to be upfront. It's much easier to be truthful and say, look, I dropped the ball. I missed a deadline. I didn't do a good job communicating. I didn't explain that to the client. I should have called more frequently. That's not uncommon. But when you try and run a game on us and try and say things that aren't true, that just makes it worse. And it turns a simple ball game into the World Series. So I encourage you to be candid and be honest and then forthright with us. After, and if it goes to the stage of an interview, part of my responsibility is to decide what to do. What's the right disposition? So I work with my staff attorneys on the case, and I talk to them about what's happened, what's the history, what's the response, what's the gravity of the conduct, and we make recommendations for dispositions. As you may or may not know, we have two levels of discipline in New York State. One is called private, and those are things like a letter of admonition. Below a letter of admonition, which is a disciplinary letter, but it's kept private, is a non-disciplinary letter called advisement. It used to be called a letter of caution, but now it's called letter of advisement. That's a non-disciplinary letter. It goes into your file, but it's simply something that says your behavior warranted comment, that you need to be more careful and more attuned to these rules. And below that, we might dismiss it if we think the matter has been resolved. Beyond and above that is public discipline. And public discipline is all issued by the court. That's disbarment, suspension, or censure. In order to go for an admonition or for formal charges in public discipline of some fashion, we have to take the matter to our committee. So the committee is a group of individuals, 21 members, 18 of whom are attorneys from the various counties in the district, and then 3 lay people. And they are all appointed by the presiding justice, and they serve a 3-year term and then are eligible to be reappointed to another 3-year term. So potentially they might serve for 6 years. If the matter warrants the committee's attention and perhaps the court's attention, I have to make a recommendation to the committee. And that is that it should be either an admonition or that it should be heard by the court. Now, recently, the rules were also changed to say even letters of advisement or caution must be submitted to the committee. But those are simply agenda items that are put on with a summary of the misconduct, and the committee votes on that. If it's more serious, such as an admonition or a formal charge recommendation that it should go to the court, then that matter also has to be voted on by the court or by the committee. So I make the recommendation, the respondent attorney is notified of the date that the committee will be hearing it, and then you are invited to come in and make an appearance, again, with counsel if you would like. My staff attorneys also will write a report that goes to the committees in advance, and it's mailed to them 2 or 3 weeks ahead of time, and you as the attorney would be given a copy of that report even further ahead. So you're going to know all the documentary evidence, you're going to know all the arguments, you're going to know the reasoning, you're going to know the exhibits and the facts that we are asserting that you engaged in. And every attorney is able to respond to that by putting in a response themselves. And in addition, in the 4th Department and in the state, attorneys are allowed to come before the committees. And in the 4th Department, that is practiced and encouraged. And very often it's helpful to have you come before the committee to show the committee whether or not you get it, you've taken corrective action, you have a degree of remorse about your misconduct, or sometimes it's not a good idea because you go in with the wrong attitude. But you have the opportunity to go in front of the committee and express yourself and respond to the allegations. So once that happens, you're excused and the committee deliberates among themselves and then votes on the recommendation. Once they pass the recommendation, you'll be notified shortly after the committee meeting And now we go up, depending on which course they've taken. If an admonition letter is issued, then it's drafted and then it's read and signed and approved by the chairperson of the committee on behalf of the committee, saying they believe that you engaged in misconduct, but the private discipline is appropriate. If the recommendation was for formal charges and formal charges are approved, my staff attorneys will write what's called a petition, which is similar to an indictment. And that is simply laying out what the conduct was and what the rule violations are that we believe you've engaged in. After a formal complaint has been issued and a formal charge issued, we serve the petition on the attorney, and then the attorney has 20 days in which to answer. Now we have a couple of options. If the attorney admits the allegations in the petition, then the case is put on for a private disciplinary day. It's separate and apart and confidentially held by the appellate division on days apart from any other matters being heard. And at that point in time, you could come in and assert any factors in mitigation and make a pitch to the court as to what the court might do. But ultimately, the court makes its decision. My office does not make recommendations and go to the court and say, you should suspend, you should disbar, you should. We don't do that because I think that's the court's province. But we do make a recommendation to the court that this may have been serious misconduct, and we point out that this has been something that's happened before versus you've had no history and so forth. So it is an interesting day in front of the appellate division where attorneys know that their career is in the hands of the court. So if the petition is denied, and some facts are admitted and some facts are denied, or DKI, not enough information to respond, the court reviews the answer and then will decide to assign a referee to conduct the fact-finding trial. Because the appellate division justices don't do a fact-finding trial. They sign it out to a retired Supreme Court justice typically, and they conduct the referee, as a referee, they conduct the fact-finding trial. Those trials are held usually in the grievance offices. Again, they're confidential, not open to the public, but a record is made and an examination is conducted. And at the conclusion of the trial, each side gets the transcript and then has a certain number of days to submit proposed findings. So rather than closing arguments, we submit a memorandum to the court saying we believe the following facts were established and proven. And from there, we will then ask that a referee adopt those findings. Similarly, the respondent will do the same, and the referee ultimately issues his or her report, and says, I find these to be the following facts, and therefore these rules were violated. That goes to the court, and the party in agreement with it will move to affirm it, and the party opposed to it will move to disaffirm. Ultimately, again, the matter will be assigned to a calendar day for disciplinary matters only and heard by the justices on the appellate division panel. And at that point in time, the court will again hear from us and hear from you, and then they will decide what, if anything, they should do when they issue their decisions after the appearance, and they typically don't do it that day. Now, the new rules also allow for that to be short-circuited by what's called discipline on consent. We can simply agree that this is a case that calls for a censure, and it doesn't warrant suspension or something. Or we might say that this is something that probably does call for suspension. In that case, we might take a position. And if we are in agreement, we will present that to the court together. And then if the court agrees with that, and again, this is ultimately the court to decide, but if the court agrees to accept it and then join motion, then that is what will happen. That would be the process. And one thing I want to ask and mention is this. In the last several years, there has been a topic called diversion, and it was instituted when I first came, and it was originally limited to alcohol and substance abuse issues. So a lot of times attorneys are under stress and they react by self-medicating or addictions and alcohol abuse, alcohol addiction, or substance abuse and addiction. That rule has been expanded to now include mental health. And if an attorney has been dealing with mental health issues and is suffering from any issues, depression, suicidal thoughts, whatever it could be, that has led to many people engaging in what would otherwise be misconduct, and yet it's obviously the root cause of the problem. The court has expanded the rule to now allow diversion to be offered and include people with mental health claims and considerations. So the respondent at any time in the process I've just described, from having the opening letter up to the day that you're appearing in court, can raise in mitigation that they have an issue and then seek a stay from the court of the matter and try and enroll in diversion, which is a state program of the state bar through the Lawyers Assistance Program. And you have to be assessed and you have to be documenting that you do have an issue. And then you agree with a mentor to participate in a recommended program. And by signing the agreement, you then apply to the court. And if the court grants that application, the matter is stayed. And you go through probably a 1 to 1.5 and sometimes a 2-year program of treatment. At the end of that, and upon successful completion, many times the charges that were the subject of your complaint can be dismissed by the court. And then you don't face the types of sanctions that you otherwise would face had you not engaged and participated in trying to get help for the problem that was obviously causing your difficulties. So we encourage people at all times to be candid. And if there are underlying problems like that, we try to get to the root of it as well and try and root you into a program that can otherwise help you and avoid this entire disciplinary process. So I'm going to be sensitive to the time limits here, and I'm going to say that that probably should conclude my remarks. If you have questions, and they can be asked today, I also want to encourage you to feel free to contact any of my offices and ask any of the staff counsel, because we are not the enemy. We don't have horns in our forehead. We are not trying to take you down and harm you. We are here to protect the profession and protect you. And if it's in your best interest to get help and treatment, we're your biggest supporters if you want to be candid with us. So again, I thank you for your time and your interest in the program, and I look forward to hearing from the rest of the participants. Thank you very much.
Thank you, Greg. At this time, I'm going to read the first code. There's 2 codes in the CLE that you have to record and submit to the Bar Association when you send in your forms to get credit. So the first code is 5166. 5166. And then we're going to transition to our second speaker today, Laura Myers. And Laura is a partner at the Wolford Law Firm, which is a certified woman-owned business. She represents small and large businesses and individuals in commercial, employment, intellectual property, personal injury, and general litigation matters. Laura has extensive experience litigating cases in New York State and federal trial and appellate courts. She also has extensive experience resolving disputes without resorting to litigation through settlement negotiation and participation in mediation and arbitration. Laura is admitted to practice in New York and Ohio and is a registered patent attorney. So Laura, I will turn the floor over to you.
Thank you, Patrick. And as Greg mentioned, I'd just like to say that I hope everyone is staying home and staying safe and healthy. And we appreciate you all being here today with us. What I'm going to cover today is a little bit different than what Greg covered. I'm really going to cover this from the attorney's perspective and provide some examples, which are pretty egregious examples of attorney conduct. I think that in my opinion, probably would arise to the grievance level and at the very least impacts some of the sanctions provisions that exist both in state and federal court. And that's something that, opposing counsel can bring as part of a motion. So the topics that I'm really going to cover are the rules of civility, and those are in our materials. Rules of civility, unlike any of the provisions of the NYCRR or federal rules, are not enforceable, but they were written many years ago, really for the purposes of aspirational standards, how attorneys should conduct themselves and how they should treat one another. The second group of rules that I'm going to go over are some of the relevant rules of professional conduct, which is 22 NYCRR Part 1200. There's specific rules. There's so many. Obviously, I can't cover all of them. So I'm going to pick a few that I think are really important to civility between attorneys. And there's a lot of overlap there, actually, between the rules of civility and specific rules of conduct. I'm also going to cover the New York State sanction rules, which can be found at 22 NYCRR 130-1.1. And that's, for that rule, it's basically, requesting relief from the court for attorneys, acting improperly. And then we have 2 federal rules, which I'll briefly cover, the rules themselves and then some cases that reflect them in practice. They're Federal Rule of Civil Procedure 11 and and federal statute 28 USC 1927. And all of those are included in your materials. Really, the point in the rules of civility is what it really governs is attorney conduct. And often you'll find in a case, litigation is adversarial. You have clients that have an extreme dislike for one another. You know, some of it's become a business, some of it can be very personal. Even what I do a lot, commercial litigation. I mean, I've had the dissolution of businesses and partnerships that are quite honestly as ugly as a divorce. Because, you know, these are people that have known each other for years. They were friends, they were family. And, you know, there's a lot of high emotions. And so the role of the attorney is to take the emotion out of the equation, you know, to never use vulgar language, to never make disparaging remarks about other parties or other attorneys, or to use overly aggressive behavior. I mean, really the lawyer's there to serve as the voice of reason and to act in a civil manner, no matter how difficult the subject matter. And this also goes for the staff that's overseen by the lawyer. You know, anything that anyone in your office does, you are held responsible for because, you know, they're your employee. So the first rule that I'd like to go over is the Rule of Professional Conduct 3.3F. It deals with lawyers appearing before a tribunal. So this is a somewhat narrowed rule because it's really just if, you know, if they're in the presence of the judge, usually if you're in court, the behavior of an appropriate behavior of a lawyer. So this includes attorneys complying with local known customs and of courtesy and practice, avoiding engaging in undignified or uncourteous conduct. Attorneys should not intentionally violate a rule of procedure or evidence, and an attorney should not engage in conduct intended to disrupt the tribunal. This actually overlaps with the first rule in the Standards of Civility, which states that lawyers should be courteous and civil in all professional dealings with other persons. This includes lawyers should act in a civil manner regardless of the ill feelings their clients may have toward others. Lawyers can disagree without being disagreeable. Effective representation does not require antagonistic or acrimonious behavior. Whether orally or in writing, lawyers should avoid vulgar language, disparaging personal remarks, or acrimony towards other counsel, parties, or witnesses. And finally, lawyers should require that persons under their supervision conduct themselves with courtesy and civility. I'm going to provide an example of a case where it's really, it's a good example because the attorney in the case has violated this rule, or both of these rules, in so many different ways that it's really kind of unbelievable. And following this attorney breaking the rules, there was a motion brought and granted for sanctions pursuant to 22 NYCR 130-1.1 for violations of both 3.3F and Rule 1, which, you know, in my experience, it's not very common for sanctions to be granted on grounds like this. And typically the conduct has to be really pretty egregious for a judge to do that. Really, the first lesson that this case presents is why an attorney should never represent themselves. The case is it's Zappin v. Comfort. It's 215 Westlaw 5511519. It's a New York County Supreme Court case from 2015. And what this case involved, which I think most of us have the common sense to know that you should not represent yourself in a child custody battle and a divorce. It's very contentious. In this case, the attorney actually was a patent attorney. He litigated complex patent infringement cases and had no experience at all doing family law cases. He worked at a big firm in New York City. And in this case, his conduct toward opposing counsel, as well as the parties and third-party witnesses, was pretty egregious. Some of the examples were that he sent his wife's counsel and the counsel's associates emails taunting them about their personal life and relationships. He submitted papers to the court including irrelevant personal information about his wife's attorney, including photos of the attorney's son. He also went after the attorney for the child that had been appointed. He wasn't happy with their observation that they believed that there was some validity to some abuse allegations and that all visits with the child should be supervised. So in response, he filed multiple motions to remove the attorney for the child. He refused to pay court-ordered fees. Shockingly, he took out a website with the web address and the name of the attorney for the child and began writing libel and slanderous messages about her and her legal practice. And finally, the attorney for the child was forced to bring an emergency order to show cause to remove the website that had been created by this attorney. Then the attorney for the child had an expert witness who had met with the child, who was a board-certified psychiatrist. The plaintiff, the attorney in this case again, wrote to the Office of Professional Medical Conduct and claimed that the doctor provided fraudulent testimony in the lawsuit and charged outrageous fees. It did not tell the office that the doctor was serving as an expert and being paid pursuant to court order. The Office of Professional Conduct dismissed the complaint within 3 weeks. Some of the other conduct actually was against the judges that handled the case. There were a couple of different judges. The first judge was in DC, where the case had been filed. This attorney submitted papers to the judge, which contained a handwritten note on the front, which stated, "You are pathetic." And then once the case was transferred to New York, to a new venue, during a hearing, after making a ruling, Judge Kaplan asked Mr. Zapin if he had anything else to say, and at which point he stated, so this is the attorney, "Yeah, Your Honor, I'm tired of these lies coming from you on the record. The motion about Dr. Ravitz was not fully briefed, and you know that, and you put it in your order. You put it in your order that I withdrew the Article 78 proceeding after the Attorney General had filed responsive papers. That's not true. He filed it after I filed a notice of discontinuous. It's lie after lie after lie that comes out of your mouth, and I am tired of it." Plaintiff's accusations of lies coming from the court did not end there. The transcript further stated, Mr. Zapman, "I just wanted to make it known on the record that I am tired of the lies coming from the court and the tainting of the record, knowing full well this is going to the appellate division. And we're going to be in the appellate division tomorrow, getting a stay. And then we'll go back to DC on Friday. And we're going to open up to Ms. Comfort's domestic violence petition. And we're going to have a hearing down there and in from Judge Blant, because that's who she lied to, saying that she filed the motion and we'll have him making a finding of domestic violence. So that's all I have to say. Are you finished? I'm finished, Your Honor." So obviously, this attorney was angry, was emotional, was attacking everyone involved, obviously including the judge, which is never a good strategy. Finally, after all this conduct, various attorneys and the attorney for a child applied for sanctions against the plaintiff. The court awarded judgment for the attorney for the child and for psychiatrist fees. They awarded $10,000 in sanctions, and that was to be paid personally by the attorney who made all of these comments. Half of which was to be paid to the attorney for the child, and half of which was to be paid to the lawyer's fund for client protections. The finding was that the attorney had violated 3.3F for uncivil conduct and granted sanctions pursuant to 130-1.1. So obviously that's a really egregious example. I think it's really rare that things get to that level, but it happens. And my guess is that the judge might have also considered, referring the attorney with that conduct to the grievance committee as well. Just an overview of the federal court rules. The Federal Rule of Civil Procedure 11 allows for the court to employ sanctions for an attorney or a client's conduct. Rule 11B1 includes where a party presents a pleading for an improper purpose, such as to harass, cause unnecessary delay, or needlessly increase costs of litigation. In one case involving this rule, it was the Supreme Court case on the matter actually decided that sanctions for misconduct can range from the dismissal of the case to assessment of attorney's fees to any other sanction that the judge deems appropriate. Under 28 USC 1927, counsel can be liable for excessive costs as a result of this type of conduct. We have an attorney or client who multiplies proceedings unreasonably or vexatiously. They may be required to personally satisfy excess costs or expenses, attorney's fees, and costs. An example of that conduct was in Revson v. Sink and Sink, 221 F3D 71. And this is a Second Circuit case from 2000. It involved a client leaving an attorney for representation by different counsel. The former counsel was refusing to turn over the files without payment or guarantee of payment of the existing attorney's fees. Counsel wrote back after finding out that he wasn't going to be getting a copy of the files, threatening the litigation would occur that would tarnish the other attorney's reputation. One lawyer threatened the other to perform the legal equivalent of a proctology exam on the former counsel's billing records and finances. This was a case originally in the Southern District of New York. The judge there heard a motion for sanctions, concluded that the attorney engaged in offensive, demeaning, and abusive conduct and had multiplied the proceedings and caused unnecessary injury to the opposing counsel and client. In total, the Southern District of New York found 11 specific actions constituting misconduct in violation of both Rule 11 and 28 USC 1927. And it did sanction the attorney $50,000 for that conduct. The thing that really I found kind of shocking was the Second Circuit actually reversed that ruling and found that sanctions actually weren't appropriate. So even after these threatening letters, the Second Circuit found that the actions taken by counsel, which were offensive, were not entirely without purpose or color. So in that situation, the attorney actually got away with the conduct without receiving any monetary sanction. Additional professional rules of conduct that govern civility that are relevant include professional conduct 8.4D, which is conduct prejudicial to the administration of justice. That's really more of kind of a catch-all. Professional conduct 8.4C is engagement in conduct involving dishonesty, fraud, deceit, or misrepresentation. These rules can be seen in another example, which is Alexander Interactive Inc. v. Adorama Inc. It's a 2014 Southern District of New York case. It's 214 Westlaw 405-8705. And in this case, there was an email from one counsel to his opposing counsel, which engaged in profanity. It used profanity throughout the email. It addressed opposing counsel with profane name and began threatening him. The attorney threatened that she had taped a conversation between herself and opposing counsel and their expert and could prove that the other attorney was lying to the court. The attorney who received the email then sent it to the judge. The attorney who wrote it then wrote a note of apology and admitted that no tape recording existed and admitted that their conduct was inappropriate. The judge ultimately decided that the counsel's conduct violated 8.4C and D because the counsel was offensive in her language and was dishonest by lying and claiming that there was a tape recording of a conversation that there really wasn't. Ultimately, the attorney was admonished and was told future conduct would result in her being removed from the case, but the judge, did not sanction the attorney with anything financially or otherwise make any negative rulings. A final example of a case where it was found that there were violations of ethical rules of conduct 3.3F and 8.4H was In re Teague, 15 NYS 3D 312. It's a First Department case from July 2015. 3.3F, again, governs just conduct before tribunal, so just before the court 8.4H is a catch-all, which governs any other conduct that adversely reflects on a lawyer's fitness as a lawyer. In this case, disciplinary proceedings were brought against an attorney for insulting and disrespecting two administrative law judges and making sexist, racist, and homophobic remarks in the presence of three attorneys that had testified. And the judge and attorneys testified that this conduct had been going on for years. So this was a situation where, you know, people were finally fed up with an attorney that had been acting completely inappropriately for so many years. Everyone had turned a blind eye to it. Finally, they reported him. In response, there was a referee's report for the grievance committee. The referee recommended that the attorney be publicly sanctioned for his conduct. The hearing panel, however, disaffirmed the referee's recommendation, and based on the years of poor impulse control exercised by the respondents, actually found 3 months of suspension was appropriate. So in this case, you know, this behavior wasn't just a slap on the wrist. They actually decided, because the person was acting so inappropriate and so uncivil, that the appropriate, you know, way to respond was to actually suspend their license. Just to go over quickly a couple of examples that are more commonly dealt with in court than this, you know, really blatant out of control incivility is rules of professional conduct that deal with things like discovery and really deal with just being, you know, obstructionist versus cooperative and things like that. This is something you obviously come across in things like discovery. Professional Rule of Conduct 3.2 is that lawyers shall not use means that have no substantial purpose other than to delay or prolong the proceeding or to cause needless expense, and to avoid frivolous conduct. So this concept of civility requires parties, it really works along with the rules in federal and state court, which require parties to meet and confer over discovery disputes, and basically to avoid the cost and expense of having to bring a motion to compel. Commercial Division Rule 14 requires meet and confer of discovery disputes. Federal Rule of Civil Procedure 26 requires to meet and confer of discovery disputes. Where a client, you know, where a client or an attorney refuse to really act in good faith, it can also be grounds to bring a motion for sanctions for attorneys' fees for having to incur the costs of, you know, bringing a motion where it's very obvious that a person needs to provide information and they're just refusing to do it, to delay or to make litigation more expensive. Another example, which I know is definitely frowned upon, is very simple requests in discovery or in a case in general, just, for example, requesting time extensions. As I had mentioned in the beginning, if you look at Professional Rule of Conduct 3.3F, comply with known local customs of courtesy and practice. So for example, in Rochester, if you're practicing in Rochester and someone asks for a time extension, you know, one time extension for the first time in discovery or in a pleading, and you say no, and they go to the judge, in my experience, the judge does not appreciate that. You know, they really expect, unless there's some really good reason, they expect for attorneys to cooperate and to be reasonable with one another. So that is it. I'm happy to hear any questions.
I'll jump in, Laura. Let's see. So I'll segue to our next speaker. I'll just remind everyone of the questions and answers, and we have time built in too. We're going to do, Judge Dollinger is going to give his presentation, and we have time built in at the end to have hypotheticals discussed and questions. So if anyone has questions, you can put them in the Q&A section below. So our next speaker is the Honorable Richard A. Dollinger. He's a judge of the New York Court of Claims and an acting state Supreme Court justice. He's assigned to matrimonial matters in Rochester. He's a graduate of St. Michael's College at the University of Toronto and Albany Law School, where he was an editor of the Law Review. Prior to being a judge, Judge Dollinger was a trial lawyer for 28 years. His public service also includes being in the Monroe County legislature for 5 years and also 10 years in the New York State Senate. And fun fact, while in law school, I was one of Judge Dollinger's summer clerks, and I had fantastic time and learned a ton from the judge. So with that, I'll turn it over to the judge.
Thank you very much, Patrick. Can you hear me?
Yep, I can hear you, and I see your screen.
Everybody can hear me. I'm assuming everybody can hear me. Can everyone see the screen I've got posted up here?
I can see it.
Okay, everybody can see the screen. Let me start with a quick thank you to both Patrick and Laura for putting this together on behalf of the UB alumni. Two other quick things. One is I issued an order that said no ties. Mr. Huether and Mr. Levy have both complied. Anyone who's watching this who's wearing a tie, you can expect a contempt proceeding shortly. Let me express my dismay to the Monroe County Bar Association because there are no virtual potato chips. Mr. Ryan well knows that I come to these things and give these presentations in large reliance on available potato chips, and there aren't any, so I'm disappointed. Let me just preface this all by saying, and I want to emphasize something Greg said. We are not here, this is not fright night for lawyers. We're not here to scare anybody. Mr. Huether is not Freddy Krueger, I'm not Norman Bates, and Ms. Myers is not the Wicked Witch of the West. What we're here to do is give you some insight into the kinds of disputes that lawyers have in their conduct in the courts and elsewhere that can cause them problems with respect to their licensure. Mr. Huether explained the process when complaints is filed. Ms. Myers has explained the penalties, and what I want to do is I want to talk to you about how is it you get to the grievance committee. And the most important fact I want to draw on is one of the possible avenues is through complaints from judges, and that's what we're going to focus on. Here we go. Let's see if I can figure out how to click this here. The golden rule of judges. Judges are under an obligation when they have information suggesting there's a substantial likelihood that a lawyer has committed a substantial violation of the rules of professional conduct, they must take, I must take, appropriate action. We'll discuss all these terms later. This is the golden rule. It's in the NYCRR, and it says, if the misconduct is so serious that it affects their honesty, trustworthy, or fitness, a judge must report the conduct. So that's the standard. Substantial likelihood, substantial violation, appropriate action, and if it calls into question his fitness, a judge must report it. But there's finer print in the golden rule. Reporting is mandatory if an attorney threatens to file a complaint, to unduly influence the judge, or deliberately deceive the court, or acted in an extremely unprofessional manner. The key thing to keep in mind is that you have to have information that shows there's a substantial likelihood. We'll talk about that term in greater detail. But if there's no direct personal knowledge whatsoever, and it's merely rumor and gossip, then judges have to determine whether it's appropriately reliable or credible. And that's where judicial discretion comes in. So again, I want to emphasize there has to be information, it has to be reliable, showing a substantial likelihood. And the other thing is the question of whether all these factors are present, these are left to judicial discretion. Judges are under an obligation to report, but many of the factors that we rely on in determining these issues are subject to judicial information and judicial discretion. The other thing that's important to keep in mind, this is just a consequence. if a judge reports a lawyer and for disciplinary action for the next 2 years, they are precluded from hearing the case. They cannot hear anything. They're barred from it. And remittal, the process of somehow absolving the conflict, is no longer present. So keep in mind that a report means a 2-year disqualification period. And here's the other thing. Even if a judge concludes that they're not required to report, nonetheless, he or she can exercise their discretion and still report them if they wish to do so. So there's mandatory reporting and discretionary reporting. We'll talk about that in a second. Some quick notes on it. We talked about substantial likelihood. Here's the practical consideration that I want you all to understand. And that's the difference between reporting by a judge versus reporting by a fellow attorney. Is there greater weight associated to a complaint from a judge? I'm not sure. I'm sure Greg would tell you there isn't. I would suggest, however, that as a practical matter, if you get reported by a judge, you may find that there's a chance that it would be taken more seriously given the judge's ethical obligations. What about the impact on other judges? I would just tell you, if your conduct causes a judge to report, that should be confidential. But the Hall of Justice, and I use this term in great deference to my colleagues, Mr. Huether, who practiced there for years, would know that it's not a citadel of silence. In fact, it's like a sieve of whispers and gossip and rumors. And I think a lawyer has to be concerned about the practical consequences. My sense is that unethical behavior may spread like wildfire among both the bar and the judiciary. I would caution everyone. It may affect your reputation. And keep in mind one other thing. Judges who are under an obligation to report may err on the side of caution by reporting if their discretion dictates it. It is subject to judicial discretion. I wanted to just emphasize the terms. Notice how subjective they are. What's the information? Does it have to be firsthand? Can it use courtroom facts, pleadings, off-the-record conferences, private discussions, all subject to judicial discretion? When does the likelihood occur? It's a term of art. What does it really mean? Does it mean might have, or does it mean like preponderance of the evidence? You must be more likely than not. The judge has to draw that conclusion about whether the event has occurred. The substantial violation, how substantial of a violation does it have to be? We'll get to some of those definitions in a couple examples. My only point is this: it's no different than any other decision by a judge. They're fact-intensive decisions in an exercise of discretion. There's no truth-finding proceeding as a precedent. Judges are not obligated to investigate and find the truth of the allegations. If in their discretion they conclude there's been a violation, they must report. Here's a couple of examples that are all gleaned from decisions by the Advisory Committee on Judicial Ethics. I sit on that statewide committee. It has 27 members. It meets once every 6 weeks in New York City. I want to just throw some examples at you to give a sense of the kinds of things that are reported. Here's an instance in which an attorney improperly notified his client's signature, purportedly as a matter of convenience, right? Not all that unusual. It does happen. There appears that the attorney did it for no other reason, had never done it on a prior occasion. Is there an obligation to report? What is the appropriate action? There's a repetition of the rule about what does it mean? And the question is, the conduct does not rise to an egregious level that it seriously calls into question a fitness as a lawyer. Then a judge has a discretion to take less severe and appropriate measures. There was a big dispute before the committee for the better part of a decade as to how substantial the violation had to be. And what they have basically concluded that it really has to get to the level of an egregious violation. That is something that is either in a single instance so damaging to the attorney's fitness, or a series of lesser episodes that when added together could constitute that. So there are alternative measures. Remember, the court only has to take appropriate action. That could include reporting to a grievance committee. The advisory committee has made it clear that counseling, warning, reporting to their employer, sanctioning a lawyer, these are all options that are available when a court considers appropriate action to a lawyer about whom it's concluded there has been a substantial likelihood of a violation. Again, I want to make it clear, we don't conduct investigations, but we have an obligation to exercise our discretion and determine the substantive nature of the violation. Should a judge take an investigation? Judges in some cases may interview the attorney, caution him. They may inquire privately with the attorney about the nature of their conduct. What I would counsel every lawyer who's ever asked a question about this by a judge, should the attorney participate in an interview? A judge says to you, I'd like to talk to you about your conduct. What should a lawyer do? Should you participate? Is the judge under any obligation to advise you beforehand that he's investigating your behavior with looking to the possibility of reporting you to the grievance committee? Is he obligated to disclose that? He is not. There's nothing I've found that suggests he should. Should the conversation with the judge be on the record? I would just caution every lawyer, as we all know, two people can engage in a conversation and come away with completely different impressions. These are all cautions. If you get to that point, I leave it up to a careful lawyer to make these decisions. But the judge has an ability to start asking questions, and it seems to me that the lawyer's conduct could be called in. This is an opinion that if you ever reach this point, this is the opinion about falsely notarizing a document by a lawyer and the question of what constitutes a substantial violation. In this case, the committee had held that even a falsely notarized signature doesn't necessarily implicate an attorney's honesty if it's an isolated instance, a single instance. And the committee wanted to make it very clear that judicial reporting is only required when the term is egregious, when the violation is egregious. The consideration is the committee has concluded that a judge only is obligated to report if the conduct seriously calls the lawyer's fitness into question. That's the guideline for judicial reporting. Another opinion that comes down that lawyers should be aware of. There are numerous factual questions about the judge's conduct the judge knows to be false. There's an affirmation submitted in which the judge believes that some facts are likely false, and the judge believes that the attorney may have violated the rules of conduct by failing to familiarize himself with applicable court rules. In other words, there are sworn statements by the lawyer that the judge knows are false, he believes some are false, and he says the lawyer hasn't done a sufficient investigation. The question becomes, does he have substantial knowledge that he's intentionally made false material statements? Under those issues, under that circumstance, he must be reported to the appropriate disciplinary committee. And if the judge has personal knowledge that a lawyer has made perjurious statements in an affirmation, it should be reported. Guidance to lawyers speculating in affirmations, making statements in affirmation that are not true, every caution should be advised to lawyers. Another example, this is 1790. This is an instance in which there were troubling instances in which an attorney sought to deceive the court, law enforcement, on an order of protection. And the question that was asked was whether this is the kind of serious conduct that constitutes a basis for reporting. In this instance, the individual had actually altered the terms of the lawyer had altered the terms of an order of protection. Again, does that meet the qualification? If at a hearing, this was done by a paralegal in the law firm, and that the paralegal had filled out a form requested by the police so she could access her belonging. An associate lawyer handling the case told the paralegal to fill out the form. The form was in the judge's order of protection. The paralegal altered the order by handwriting a clause which changed the order of protection. They get before the court, and the partner walks in and says, "Judge, our paralegal altered your order of protection. What's the consequence?" The lawyer said they revised their procedures. The judge asked 3 questions. Must he report the conduct to the district attorney's office? Must he report the law firm to the grievance committee? And should he take any further action? The rules of governing judicial conduct are silent regarding a judge's obligation to report a non-lawyer, all right? There was no obligation to report the paralegal who altered the order to the district attorney's office. However, if the law firm's conduct and the partner who oversaw it, if it raised troubling questions, then this matter should have been reported to the appropriate disciplinary committee. Even though the lawyer didn't do it directly, nonetheless, one of his employees did, for whom the lawyer was responsible. And the question is whether he exhibited extreme carelessness in supervising his subordinates. That could not only be paralegals, but associates as well. Again, they were advised to report it to the committee, or to the grievance committee. And therefore, the final rule is, the judge, did he have an obligation to investigate the truth of the allegations, hold a hearing? The answer was no, he didn't. The reason why I mentioned that one is because lawyers need to realize that they can be held to account for the conduct of their paralegal or other employees that they supervise. It can be the subject of a report to the grievance committee. This is an instance in which a lawyer files a complaint, says that he advised his client that the case was settled when it wasn't. And in fact, he had paid the settlement fees, not from an award given by the court or a jury, but from his own personal funds. The question was, the judge asked the lawyer had deceived his client regarding the settlement offer. In this instance, that seriously called into question the lawyer's honesty and trustworthiness, and therefore he was advised that he should report that to the disciplinary committees. What about an attempt to influence the judge? This is similar to the instance that Ms. Myers mentioned. An attorney accused the judge of having engaged in ex parte communications. He said, I'm going to report you to the Commission on Judicial Conduct if you don't undo your decision, and expunge the record. Judge, your conduct is illegal and unethical. The judge says, I tried to explain it. I didn't have them. The attorney continually interrupted him, and the judge finally agreed to look into it and give the attorney a return call if the judge found something was amiss. Just so you know, doing a return call to a lawyer privately is a bad idea for a judge. I would recommend he not do that, but it doesn't matter. Nonetheless, he was convinced that he had reached the right decision. What does he do? Does he report this lawyer? If he's unduly attempted to influence the judge's decision and acted unprofessionally, he gets reported. And under those circumstances, the committee concluded that he must report to the attorney to the appropriate disciplinary committee. You don't get to stand and accuse a judge of doing unethical and illegal things without having some consequence. Just a caution to all the lawyers in our audience. A series of opinions about political conduct. An attorney, as an officer of a political party, signed an affidavit which contained a false accusation against the judge in an election campaign. I'm going to condense this into a really careful, this long discussion, but these were complaints about the judge being involved in courtroom conduct in which he asked the lawyer to lend his name to the judge's election committee. Clearly conduct that is not permitted by a judge. There was a big dispute about whether it happened. The judge denied that it did. The lawyer goes out, signs an affidavit in which he says the the judge was conducting politics in the courtroom. The question is, can he report this should the city court judge report this to the grievance committee? The committee concluded that the judge had concluded that the lawyer had lied under oath regarding the judge's conduct. And that implicated the lawyer's honesty and trustworthiness. And under these circumstances, the committee concluded that the matter should be referred to an appropriate grievance committee. Again, everybody needs to understand that's an affirmation signed by a lawyer, not in the proceeding before the judge, but outside the proceeding, which calls into question the judge's conduct, which the judge believes to be untrue. Just everybody a caution, even though you're not in a courtroom, you may still find yourself engaging in the type of conduct that could be reported. When not reporting implicates a judge. I talked earlier about the requirement that judges report lawyers. What happens if a judge becomes aware that there is unethical or inappropriate conduct and fails to report it? This is a case that actually was heard before the Committee on Judicial Conduct. Succinctly put, this is a surrogate who hires a public administrator, and he finds out that the public administrator is doing all kinds of nefarious things, stealing from his clients, overcharging estates, lied to the judge, lied to the court, filed false affirmations. And in these circumstances, the judge failed to report the lawyer, and the Committee on Judicial Conduct was asked whether his failure to report the lawyer implicated the judge's credibility and the judge's ethical responsibility. And under those circumstances, in the matter of Holzman, which came out in 2013, the judge was censured because he knew that the lawyer had engaged in activity that should have been the subject of a disciplinary proceeding. Again, just understand that judges have obligations too. What about how bad does the conduct have to be before a judge has to report someone? This is an example of a lawyer who's engaged in misconduct. He's extremely rude, he's malicious, he's got belligerent behavior. He actually starts stalking one of the judges at his residence. He made complaints against one or more of the judges. The interesting thing about this is the judges had only really secondhand knowledge of this. They talked to their administrative judge. The question was, should they report the lawyer? Is stalking the judge bad enough? The advisory committee, this opinion came down a year ago. And they warned that, listen, a judge has to have direct, although he really needs reliable and credible information before the substantial prong, the substantial likelihood is met. And under these circumstances, he wasn't obligated to report the lawyer, but in his or her discretion, they may do so. My guess is in this case, once that opinion was issued, the judges who had been threatened filed a grievance against the lawyer. We can't have lawyers going around stalking judges, even if it's just by rumor. Reporting on health issues, this ties in with something that Greg Huther mentioned. What do we do with the lawyer who, appearing before a judge, he's unable to perform basic functions to discharge his responsibilities. He's disorganized, occasionally distraught, struggling to keep up. He fails to respond when the court tells him to file accountings. And here's the point. The judge had concluded that the lawyer had failed to comply with a request that he go to the lawyer assistance program. He had failed to follow instructions of the lawyer. And under these circumstances, the judge, remember, the goal of reporting requirements not to punish lawyers from the slightest deviation. However, if he concluded that his trustworthiness and fitness as a lawyer, and I believe there was a justification to do that, he should report him to the disciplinary authority. But even if he's not obligated to, remember, a judge has the discretion to do so. And in my experience, oftentimes they will, to err on the side of caution. This is a continuation of that. Again, if the conduct is serious enough that calls into question, and the judge has to make a determination whether this is a single anomalous situation or an ongoing prevailing condition, If it's the latter, it's going to be reported. If it's the former, other steps, other forms of appropriate action can be taken. I wanted to mention one other thing before I finish, because this is something that should terrify every lawyer. You've probably never heard of the misprision of felony statute, right? I'm not going to ask, I'm not going to conduct a poll, but I'll bet you almost nobody out there has ever heard of it. But it's in the books. It's in 8 U.S.C. Section 4, and it says, in essence, anybody who knows that a felony has been cognizable in a court of the United States conceals and does not as soon as possible make known to some judge or other person in civil military authority can be imprisoned for up to 3 years. If you know your client has committed a felony, are you obligated to report it? If you know that another lawyer has committed, if you know that a judge has committed, are you obligated to report it? The answer is yes. And here are the elements. You know that the crime has been committed. You know that you have knowledge of the fact. You didn't notify the authorities, and you took an affirmative step to conceal the crime. That's misprision of felony. All lawyers should be aware of it. It comes down to lawyers. Here's a classic example. Here's a lawyer who pled guilty to misprision of felony, was put on probation, he had to pay a large fine. And the question in this case was, can a lawyer walk in and defend himself in a misprision allegation because he relies on attorney-client privilege? He says, I wasn't under any obligation. I have no obligation to disclose that. But in this case in Texas, the Texas court said, and it's critically important, a conviction for misprision could conceivably be based on an attorney's refusal to divulge confidential information. There's no exclusion, there's no exception in the federal statute. One of the questions that isn't resolved, even at this point, is whether attorney-client privilege protects a lawyer from an allegation of misprision of felony. How does it come against lawyers and judges? And then I'll conclude in just a second here. Here's a case that comes out of Louisiana, of all places. There are two things about New Orleans, Louisiana. One is, I think corruption goes right with New Orleans. And number two, isn't everybody in the restaurant business in New Orleans? Here's a case where a lawyer gets involved in a heated custody case. He's an advisor to the husband who owns a restaurant. The lawyer calls the judge, and he and the judge start to conspire about how they can rig the divorce action to benefit the attorney's friend. He gives the judge information on the restaurant's activities, and he helps the judge try to get a lucrative seafood contractor. And when his daughter turns 21, the lawyer comps the judge for a party at the restaurant. The FBI gets the scent. They contact the lawyer, and they say, what do you know about this? And he says, I don't know anything about it. He fails to disclose the conspiracy and that they were conspiring against the wife. Just remember, the judge is not his client, he's his friend. Sure enough, he later admits that he had actual knowledge of the conspiracy. He was found guilty, he pled guilty to misprision of felony because he affirmatively concealed the extent of his knowledge when he was questioned by the FBI. Just keep in mind, he pled guilty, year in jail, $10,000 fine. That comes out of Louisiana. One other caution, what about immigration? I'm just going to throw a couple things out there. What about immigration lawyers who know that their clients are here illegally? You have an obligation to disclose that. What about criminal lawyers who know of criminal conduct by their clients? Are obligated to disclose. What about tax lawyers? What about judges? The bottom of this slide is an article that I wrote about judicial ethics and an obligation to report tax evasion and support cases. I did want to call your attention. Lawyers and judges are finding misprision of felony. And the United States against Scruggs is an interesting case because what happens in that case, a bunch of partners in a Mississippi law firm go to work to bribe a judge. One of the associates at the law firm finds out about the bribery scheme, but he's an associate. He assumes that he should keep his mouth shut. The partners all went to jail for bribery. The associate at the firm went to jail because of misprision of felony for not disclosing the fact that he knew about the scheme. The United States against Baumgarten from 2014 involves a judge who gets involved with a litigant in front of him and a criminal defendant. They become lovers. He knows that she's in the drug trade. He knows all these people in the drug trade. And the question was whether he had an obligation to disclose it. They concluded he did. He was found guilty of misprision and felony. That's a short summary of the issues. Just remember, judges are going to be the one source that are legally obligated, ethically obligated, just like your fellow lawyers, to report on ethical conduct that's a substantial violation, a substantial likelihood of a substantial violation of one of the rules, and it calls into question a lawyer's fitness. Under those circumstances, judges are obligated to report you. And in my experience, even if you get close on any one of those factors, a judge will exercise his discretion and you'll be reported to the grievance authorities, which cues you into the process that Mr. Huether described and subjects you, among other things, to the penalties that Ms. Myers described. I'm done. If you have any questions, maybe I can give you some answers. I'd be glad to listen. Again, thank you to Patrick and Laura for putting this together. And I'll have to find my potato chips elsewhere.
Thank you so much, Judge. And thank you to Greg and Laura. We'll start off our questions with a hypothetical, and hopefully people can enter into the chat box if they have specific questions. So the first hypothetical is dealing with a dishonest attorney. And the situation is, while your clients understandably are more emotional when involved with litigation, counsel on each side should still be civil and professional. But what about in contentious litigations where adversaries might bend the rules a bit, or might even, dare we say, fabricate facts and thus misstate the law? In briefs submitted, or even during oral argument, what happens if opposing counsel has blatantly lied to the court concerning facts of the case and made misrepresentations about relevant documents? How should we handle advocates who have clearly made factual misrepresentations to the court? Will counsel run the risk of annoying the court by raising the numerous misrepresentations made by counsel if a lawyer decides to bring opposing counsel's misstatements to the attention of the court? What's the best way to do so? So there's a concern that some courts might turn on individuals speaking up and find that calling out the adversary as a liar is unprofessional or uncivil. So now the client's outraged, wants sanctions against the lying attorney and their client, and what should be done in this situation? And so we'll hand this hypothetical off to our speakers.
Report them all. I would send that everybody involved in that. One of the things that I want to emphasize again, judges are not obligated to conduct the investigations. We leave it to Mr. Huether and his staff to figure out who's telling the truth and what the truth is. Our only obligation is if we're convinced that there's information that shows a substantial likelihood of a substantial violation, we turn it over to the grievance authorities. And frankly, I think judges tend to give lawyers a lot of leeway in these things, but sworn statements under oath that are not true, that kind of uncivil behavior, I'm going to kick that to Mr. Huether's enforcement division. Let them figure out who's telling the truth and what it is.
Well, and I appreciate the opportunity to do more work, Your Honor. Thank you. I would refer the parties to 3.3A1 because there's both an obligation to refrain from making false statements to a court, and there is also an affirmative obligation to correct them when made. And I've seen this situation, and I've seen attorneys approach both, if it's during the motion argument, for instance, calling into question whether or not what opposing counsel just said is true. I've also seen it where it was raised after the appearance by one attorney saying to the other, you know, I don't think what you said is fair and true, and I think you have an obligation to correct it. And if the other opposing party agrees with that, then he may take the steps necessary to correct it and not let the court rely upon it. That may alleviate, you know, the problem. But if the person persists in saying no, and it's a substantial allegation or a substantial misstatement, 8.3 is the duty to report one attorney to another. And, you know, that is often the basis for some complaints that are referred to our office. I'll let Laura and others, chime in as well, please.
Yeah, I've actually dealt with this situation. And sometimes I guess one thing to keep in mind is I don't know sometimes if it's intentional. Sometimes people will misstate facts, and sometimes, unfortunately, I think it might be, but other times people, if you've got a huge record before you, they might just make a mistake. And I think if it's a simple enough, point, you could probably, if it's during oral argument, just say, actually, I don't think that's correct. If you look at this document, or you refer to the person, to the correct answer, I think that takes care of it. If it's something really, if it's more of an elaborate, or there's multiple examples, I have written a letter to the judge after the argument to raise the issues, although I think Greg's suggestion is a very good one, which is give the attorney an opportunity to do it themselves and say, call them out on it and say, hey, I know that you misrepresented these facts. Are you going to tell the judge that, or am I going to have to? And obviously I've also come across it in briefs, in which case, in my responding brief, if I do get one, I'll, drop a footnote and I'll say, these are misstatements of facts that were made in this brief. I think in a brief, it's a little easier than when you're on the spot in an oral argument. But I think, yeah, I agree. There's no question it should be corrected, because like I said, intentional or not, the court, the court needs to know all the correct facts.
Okay, thank you. I just saw that a question was submitted in the Q&A. Pat, do you want to perhaps bring that to the panel's attention before we get into the second hypothetical?
Sure. And I just know we're running a little bit long. So actually we're at our time limit. So let me read out the second code. Everyone needs to write down the second code and submit it. So the number is 0320. 0320. And I think we're just short on time. So I don't know if we want to get into the other hypos or questions. So maybe just, Laura, if you want to do the wrap up, because I think, sorry, everyone, we're at our time limit.
What was the question?
The quick question was it suggested that immigration and criminal attorneys have a duty to report clients who they know are in the U.S. without documentation, or clients who know they have broken criminal laws? That does not seem correct. Please clarify. And I think this goes to Judge Dollinger's last slide.
I simply wanted to point out this. I looked for case law that would clarify that the attorney-client privilege is a defense to a federal prosecution for misprision of felony. And I couldn't find any. What I found was that there were several lawyers who had asserted that in some form of a proceeding, and nonetheless had pled guilty to misprision of felony. So I don't know that there's a specific holding. I'm just advising everyone that I think since there's no exception under the misprision of felony statute, I'm not sure how that comes out in the wash. That's all. I'm just giving everybody that caution. It would seem to me that the longstanding protection of the attorney-client privilege should apply, but I can't sit here and tell you to count on it.
Thank you very much for clarifying, Judge. And thank you everyone for joining us. And thank you to Greg, Laura, and Judge for your time and your preparation in joining us live for this CLE. And as a reminder, please make sure you send your evaluation forms and everything to Danielle. Thank you so much, everyone. Bye.
Thanks, everybody.
Thank you.
Thank you, everyone.
Thank you too.